Hi everyone, Mark Merrill with Firm. On our Special Files program, folks, we're talking about another Democrat violation. Surprise, surprise, surprise. Republicans aren't helping any. They don't get off the hook either. But this is about another LD bill, 2150. Mark that one down, folks, and we'll make sure it's in our comments and our notes at the end of the program. LD 2150. An act to establish procedures for restricting access to state property, access to state services, and communication with or through state entities in 90 days. Oh, yeah? Sounds like another emergency piece of legislation, Democrat indoctrinated lawfare, if you ask me, to keep legal citizens in step with the Mills government. Here we go again, ladies and gentlemen. So, we have a brief summary and a rundown of it. Here we are. The bill prohibits an entity of the state from restricting a person's access to state property or services provided by the state, or restricting a person from communicating with or through the entity for a period of more than 90 days unless certain conditions are met. Huh? It requires an entity of the state to include on a notice or communication restricting a person's access or communication the factual basis for the entity's decision. I'm lost already. I don't know about you. The bill requires an entity of the state. This is a department or a state division. An entity that's seeking to extend or renew a restriction issued by notice or communication for more than 90 days to file through the Department of Public Safety, Bureau of State Police, a complaint, of all things, for protection from harassment and provide evidence to the court of the original notice or communication restricting the person from accessing state property or services provided by the state, or restricting the person from communicating with or through the entity, along with the factual basis for the entity's original decision. The bill requires the court to prioritize complaints filed for protection from harassment that are unrelated to the extension or renewal of a restriction for more than 90 days. The bill clarifies that an action brought by an entity, a division or department, of the state, and filed by the Department of Public Safety, Bureau of State Police may be filed and heard and determined in any division of the district court system of the plaintiff's choice. Wow. Choices. And that the court or courts may direct a defendant to refrain from being in the vicinity of state property. I kid you not, folks. There it is, just the way I read it. And here's the title right here. An act to establish procedures for restricting access to state property, access to state services, and communication with or through state entities in 90 days. Hope you're not listening to this while you're having supper. Now, once again, Maine citizens, from border town to border town, we speak to you. North, south, east, west, and rocky shoreline all included. The GOP House Minority Leader you see before you here, Billy Bob Faulkingham, has reviewed this so-called emergency resolution bill because the deflectocrats, as we call them at Firm, the Maine Democrats in this case, like all other legislation they put off or table in this case, now must make up for lost time, or actually wasted our taxpayer dollars' time, so that Janet Mills can concentrate on running for Susan Collins' U.S. Senate seat. Boo hiss. Gonna be blunt and to the point, folks. So, we have Mr. Faulkingham's warning to all you law-abiding Maine voters and new voters about this LD 2150. Oi. But I see it now. I'm not going to try and set you up, Billy Bob. I'm not. But what I'm going to say is that it looks to me like a setup for failure with the general public again. Does it seem that way to you on this?
I think, yeah. So, if I remember correctly, I think I know where this bill came out of. Yeah. It was because the Maine Wire came in to report, and their reporter wanted to come into the House chamber and come down with the other media outlets, John Featherston, and he was temporarily denied access because they said he didn't have credentials, and there became a dispute about media access and this whole credential thing, and then so eventually he did get access, but there is actually no technical credentialing. All these media people, like, see this thing you have on your chest? It's these are your credentials. You made this yourself, right?
No, I had it made up.
Yeah,
right.
Yeah, you made it.
Yeah.
But all the media sources, they just make their own credentials. So there's nowhere that there's an official board of credentialing or anything like that. It's part of the First Amendment, the free press, that the media, right?
Well, yeah.
So
That's another case of them making up the rules as they go again?
Kinda, yeah. And so you see the downside to this bill is this looks like this is prohibiting the government from denying access, but actually what this is doing is it's sort of allowing the government a 90-day period to prohibit somebody. Okay?
That's where the 90 comes in.
So this is what this is made to look like is an intention to stop the government from prohibiting. But what this is actually doing is creating a statute whereby they're giving themselves 90 days leeway to prohibit somebody, in which that person has to fight them to regain their ability to have access to government places. So unless I'm convinced otherwise, that's what I think is happening here. But it did bring up the whole, the issue did kind of bring up some awareness that there is nothing sort of statutorily surrounding that sort of access type of thing, other than traditions, which aren't statutes. So I think that's where we're at with that. I know that's kind of in the weeds, and a lot of that is sort of editorialized by myself, and I'm not claiming to always be right, but that's just that's just sort of my take on it for now. Now, as far as that goes, I always listen to my committee members.
Sure.
I always see how the hearings go. I'm going to wait for them to give, I'm going to wait for my Judiciary Committee members to give me feedback on that, because they're the ones that are going to have the public hearing and the work session and know all the details. And many times these bills, as they're written, when they're submitted, end up changing drastically by the time they come out of a committee. So that being said, I'm going to wait and see what my committee has to say about this.
Indeed. Thank you, Mr. Faulkingham, once again. To get more of this in perspective for everybody out there, folks, we'll present a follow-up. And the follow-up is that in Section 3 of the content of this bill, LD 2150, Section 3 says a report no later than December 1st, 2027. Section 3, a report, states at the end, before the summary, no later than December 1st, 2027, the state police shall, within existing resources, submit a report of its finding and recommendations, if any, to the Joint Standing Committee on Judiciary. So, got a ways to go here on this, folks. In our election year of 2026, number one, or number two, we should say, you better beware of this lady, folks. She's not our friend in state government as far as the laws of our state are concerned. She is Alicia Melnick, attorney for law firm Bernstein Shore, representing the Maine ACLU, Maine American Civil Liberties Union, in support of LD 2150. That's right, in favor. Now, we went a little bit further this time, folks, and we got ourselves the ACLU website. I'm going to show you a couple of things here, but she's no friend of ours, folks, because they don't stand up for Maine rights, Maine citizens' rights anymore. The city of Sanford is refusing to release public records after a lawsuit was filed by the ACLU to attain them. What are they? The public records in the city of Sanford, public records related to their police department's cooperation with the federal Immigration and Customs Enforcement Agency. City of Sanford being sued. They said, no, we'll take this to the Supreme Court. FOAA or FOIA, violation. Federal Office of Information Act, violation. Next, Maine's cooperation with federal immigration enforcement. The Trump administration is using Maine to facilitate its mass deportation and detention efforts. We're demanding more information, says the ACLU. A glance at that one, folks. Couple of more. This lady's trying to make it a lot of things in her pocketbook, both from her attorney at law firm, Bernstein Shore, and also the ACLU at the same time. The Supreme Court is to hear high-stakes Maine case on birthright citizenship as well. Immigrants' rights advocates are going to argue a critical case before the Supreme Court later in their term, possibly in June, like a lot of things are building up on them. Courts have uniformly rejected President Trump's attempts to strip away a core constitutional issue. One of the court cases, Barbara versus Trump, class action to protect birthright citizenship. On the very top there, folks. And last, back on March 5th, the Maine Senate passes a landmark privacy bill. The Senate passed data privacy legislation to limit sweeping surveillance and protect civil rights. Bull crap. And March 12th, the ACLU of Maine sues Sanford for withholding records on ICE and CBP collaboration, as you just heard. But the organization is seeking records about traffic stops also, during which Sanford police turned a person over to ICE or Customs and Border Patrol custody, other Maine agencies have responded in full to 112 identical requests. Garbage. It's garbage, folks. This lady can pound sand. One final viewpoint here, folks, and some common sense on our program in regard to LD 2150, just another Democrat violation. This is going to be from Words for Warriors, folks. Fantastic book. Everybody should get a copy of it. It's by Sam Sorbo, as you can see at the bottom. It is all about Americans, good, law-abiding Americans, to fight back against crazy socialists and the toxic liberal left. Get yourself a copy, folks. It's really worth it. As we read from hers, in one that's particularly appropriate for this particular issue. You've heard of the phrase red tape? The colloquial phrase for excessive bureaucratic government regulations and control. City or state agencies or officials requiring endless forms, licenses, committee approvals, filings, inspections, and investigations, as Mr. Faulkingham here was just talking about. It's government run amok. That's what red tape is. Seeking self-justification. The more rules they write, the greater is the need for enforcement. Adding insult to injury, most regulations are edicts. They are not passed by any legislature and are written by unelected officials, thus allowing elected officials to officially denounce the regulations without taking responsibility for them. I didn't do it. No. Let's blame the attorney, shall we? Oh, might as well. Overwhelming red tape inhibits people from starting businesses and impedes smaller businesses from competing with larger ones because of the excessive cost to maintain compliance. Challenging red tape typically results in delays, fines, rejections, lawsuits, surprise, or, alas, more regulations. Red tape is a boot on the neck of the American citizens' breathing capacity. Freedom of expression. It discourages innovation and kills opportunity. All that tape would be better used to bind the hands of bureaucratic officials. And a quotation from a Jeffrey Davis, congressional representative of Kentucky at the time. The sooner we rein in the red tape factory in Washington, D.C., the sooner small businesses can get back to creating jobs and helping more Americans find an honest day's work. Thank you, Ms. Sorbo. As always, ladies and gentlemen, thank you for joining us here on Firm. Mark Merrill, as always, your host. We are all about truth, facts, reality, and common sense right here. You can contact us 24 hours a day, 7 days a week, fairnessinreportingmedia@gmail.com, fairnessinreportingmedia@gmail.com. We are on Twitter or X, YouTube, and Substack. Pray for our country, our state, in the year 2026. And everyone out there, stay safe. Peace to all.